comforting, and then take it away, Jackie.
Okay. Hi, everyone. I'm Jackie. I'm an attorney partner with Silverman Bain here in Palm Beach County. We're healthcare and business attorneys, and we've been kind of working. I've been working to put this together, and right up until this morning, I was making changes to this document because this is a legal update for 2023. So what we'll do is we will go through the 2022 federal laws and orders that were passed and have become law, 2022 Florida laws and rules that have also become law or will be becoming law as soon as the rules take effect or they're scheduled to take effect. Then we'll do the 2023 proposed federal laws, 2022 proposed or 2023 proposed Florida laws. And then we will talk about reproductive access laws and telehealth laws. I've pulled those out specifically because they seem to change every day. So we certainly want to give them their due. They will take up quite a bit of this presentation, mostly because there's been a lot of moving and shaking in these particular areas of reproductive access and telehealth, and we want to ensure that you walk away today at least knowing where you stand today, because again, things change seemingly every day in these areas. Okay, so we'll start with the 2022 federal law that talks about the COVID EIDL fraud statutes, statute of limitations. EIDL was a part of the pandemic protection programs that were put out to help businesses kind of, sustain themselves through the pandemic. EIDL was a smaller loan program than the PPP, but many businesses did take advantage of it. And so last year it became law that looking back on your EIDL applications, if there's any fraud in them, there's a 10-year statute of limitations. So it gives the government a little bit of time to go back and see what's actually been happening, because obviously those protections were put out so quickly that they weren't necessarily ready for the amount of fraud that was coming their way. So again, it's a 10-year statute of limitations for EIDL fraud. A big law, big bad law, if you ask me, in 2021, 2022 that came out was the No Surprises Act. And what's important when you think about the No Surprises Act is that you understand that this law is still being implemented and it is working its way through the courts. So there are a lot of questions when it comes to the No Surprises Act, but there are not a lot of answers right now. So the courts are, even as recently as last week, ruling on certain parts of the act that were being implemented. So you certainly want to ensure that, that you're kind of staying on top of this. If you are an out-of-network provider or your office is an out-of-network provider that provides emergency or non-emergency services at facilities that may be in-network. So say, for instance, you are an orthopedic practice administrator, your doctors go to a surgery center that is in-network with an insurance provider that you are not in-network with or that your practice is not in-network with, the No Surprises Act will likely apply to you. It's split up into three parts. The first part is the non-emergency services provided at in-network facilities. So these are, again, non-emergency services. The notice and consent is required from a patient prior to providing out-of-network services at an in-network facility. The patient has to know that you are out-of-network or that your practice is out-of-network before the work is actually done. Again, these are non-emergent services. So the patient is able to speak with you prior to actually receiving the care. They're supposed to be noticed. And I think this is something that many practices have been doing for many years. I know when I've gone in for surgeries, if say the anesthesia group was out of network, that's something that I needed to sign off on before going under, things like that. So you certainly want to make sure that this is something that you have in place. This is the physician's responsibility. Don't let the facility tell you that they will take care of it for you, because if they don't take care of it for you, or they don't do it adequately or appropriately or in compliance with the law, then your physicians are at risk for it. It's a $10,000 fine for each non-compliant action. So it's a big one. You want to make sure that you have the procedure in place to ensure that the patient notice is collected and consent. Okay, so then we move into part 2, which is emergency services and post-stabilization care provided at network facilities. In short, if an insurer covers emergency services for a patient, then the insurer must cover all charges for emergency services that are provided, whether it is provided by an out-of-network or an in-network provider. So if you're working with an insurance company that says we're not going to pay for your emergent care that you provided in an in-network facility, and you're an out-of-network provider, then that's something that you are able to go to a dispute resolution charge over, or kind of negotiate out with the provider. So there are circumstances where out-of-network providers can balance bill for care after an emergency, and this is kind of what we're talking about here. Part 3 is that good faith estimates for self-insured pay and uninsured patients must be provided to patients prior to providing care. So if you are an out-of-network provider and a patient comes to you and says, I'm not insured, if it doesn't matter if you're in network or out of network. If a patient comes to you and says, I'm not insured, I'm going to pay for myself, then you have to provide them with a good faith estimate of whatever you're going to do for them is going to cost. And if the bill actually winds up being more than $400 in excess of what the good faith estimate states, then there's a dispute resolution process that's been implemented to kind of come to terms with what happened here. So this is for all patients, again, all people who are providing care to patients who are self-paid or uninsured. There can't be any surprises about their bill. One thing that I wanted to kind of touch on here is there is a federal independent dispute resolution process that has been established to determine when it's appropriate for an out-of-network rate, what an appropriate out-of-network rate is when negotiations between a patient and their insurer break down. So there is a process there, and that's something that you want to avail yourself of. You are required to, as an out-of-network provider, negotiate for like 30 days prior to engaging the process, but it is there for you. So there are really 2 dispute resolution processes here that are kind of commenced under the No Surprises Act. One is a dispute resolution process for an out-of-network provider who's provided emergency care and would like to be paid an out-of-network rate, and that's between the provider and the insurance company. The second is between a uninsured patient or a self-pay patient and a provider who has provided a good faith estimate and then billed substantially in excess of that estimate. And again, substantially is currently defined as $400 in excess of. So now we'll kind of flip over into Florida laws that passed in 2022. The first is kind of a fixer bill. So a lot of times in legislature, there is something that comes in that's introduced late in the legislative process, maybe isn't as thoughtfully drafted as it should have been, and has some unintended consequences. So an example of that is in 2021, the Florida legislature passed a Parents' Bill of Rights. It made it a crime for any medical provider to provide medical services to a minor without first obtaining parental consent. Obviously, there were reasons that this went through, that the legislator passed this, but there were some unintended consequences. In this case, physicians and other healthcare providers said, hey, wait a minute here. What about emergency medical care? If a minor is in distress and a parent isn't readily available, what do I do here? So in 2022, House Bill 817 was passed, which allows for physicians, and it's specific to physicians, medical doctors and doctors of osteopathy, to provide emergency medical care to any minor who has been injured in an accident or is suffering from acute illness if the doctor concludes with a reasonable degree of medical certainty that delay in providing the care would endanger the health or physical well-being of the minor. And that can happen anywhere. It doesn't have to happen in an emergency room. If, say, a physician is at his or her child's sporting match and a kid gets injured, the physician can render care even if the parents aren't there. Generally, the Parents' Bill of Rights was enacted to stop minor patients from receiving medical care that was non-emergent, care that they thought they might be old enough to handle on themselves as a teenager or something like that, without involving their parents. They didn't think about the consequences when they passed it, that emergent care doesn't always have a parent readily available. So this is a fixer bill that was passed, and it's certainly something that I know the Florida Medical Association was involved in pretty heavily. So it's certainly something that physicians, kind of went to their lobbying bodies and said, hey, we don't want to be, brought up on a crime for like helping set a bone for a kid who's on a baseball field. So that's something that that was fixed in the 2022 legislative session. The next law that was, there were rules passed by the Florida Medical Board and Florida Osteopathic Board at the end of last year. They're effective next week, that talk about gender affirming care in minors. So right now, the Medical Board and the Osteopathic Board have passed these rules. The rules are set to become law, and starting as of the end of next week, sexual reassignment surgeries and hormone blockers are not available for patients who are minors, new patients who are minors. This does not apply to patients who are currently receiving the gender blocking hormones or anything like that. But new patients, this is something that they are unable to be treated for until they become the age of majority. This rule is, again, it's a rule of the medical boards. So it's interesting that the medical boards have kind of undertaken this. What it means is a physician who performs these kinds of surgeries or prescribes these kinds of hormones for minors can be disciplined up to and including the loss of their medical license. So it's not necessarily a crime, but it is something that could really have dire consequences for physicians moving forward if they continue to go forward with it. And again, any physician who goes forward with it and is disciplined, say in the state of Florida for providing these services, would have to report that to any state where they are licensed, and may have consequences in the other states as well. So this is something that is obviously highly political. It's something that we certainly want to make sure that physicians in pediatric care, OBGYN care, endocrinology are aware of. That next week, any new patients that are seeking gender affirming care will not be able to obtain it until the age of majority. Now we'll move on to proposed federal rules. Like I said, we're kind of moving through these fast because the big ones are coming up later, and we'll take those separately, and that's reproductive access and telehealth. So the federal rule is up for comment right now. So the way that statutes are written is kind of, you have your big overarching statute that's, kind of, I'd say it's like your 10 commandments, right? So they kind of say things short and sweet, and then the rules are promulgated afterward, and they kind of get down into the nitty gritty of, but what if, but what if, but what if? So your statutes are kind of your overarching thoughts, and then the rules kind of come in underneath and say, here's the actual nitty gritty of what the statute is intended to go against or for. So we have these federally facilitated exchanges that were passed under the Affordable Care Act. They come into play, especially here in Florida, because our physicians obviously are servicing patients from around the country. You've got your snowbird patients and things like that who come here, and they they're having a hard time getting prior authorizations for certain specialty care because there's a kind of whole tangled web of Medicare Advantage programs, CHIP programs, qualified health programs, and things like that that they need to go to receive prior authorization for certain care. This proposes somehow to to streamline that process and make prior authorizations, obtaining prior authorizations easier for patients who have Medicare Advantage plans, Medicaid fee for service, CHIP, they're covered by the Children's Health Insurance Program, Medicaid managed care, qualified health programs, anybody on a federal exchange, hopefully will make the prior authorization process easier. So it's a rule that will be followed by a process. It's certainly something you want to keep an eye on if you've got an aged or pediatric practice where you take any sort of Medicare plan or children's health care plan. And again, these are proposed. This isn't new. So this isn't actually law yet. So this is certainly something that if you would like to have a comment on, you have the opportunity until the 13th. So, get those comments in. Florida has a whole bunch of proposed bills. So Florida, the legislative session started yesterday. So bills were required to be kind of uploaded and proposed as of yesterday. For any dermatology practices out there, Senate Bill 142 was proposed earlier this year, and that proposes mandatory insurance coverage for annual skincare screenings performed by a dermatologist. So this certainly could prove to expand your patient base for people who may have been avoiding their annual skin cancer screenings for monetary reasons. This would cover it by their insurance companies if it passes. Right now, it's just a bill. It's kind of working its way through. Many bills die off before they're actually enacted into law. So something to keep an eye on. For those of you who are in osteopathic practices, Senate Bills 156 and 158 propose Florida joining the National Physical Therapy Licensure Compact, which is similar to the Nursing Compact, allowing for physical therapists from other states to provide physical therapy services here in Florida. There is a physical therapy shortage in Florida, and so I think this is probably why these two senators brought these bills into play. These are not bills that are intended to be interpreted together. They're separate bills proposed by separate senators. So presumably one will kind of wind its way through further. This morning I was taking a look at what the commentary was on these bills, and it does not seem likely that they will pass at this point, but it is certainly something that you want to keep an eye on if you're in a physical therapy practice. And then House Bill 173 is in kind of winding its way through the legislature. And what's interesting with this is the governor has really indicated an intent to review and perhaps revise the ability of pharmacy benefit managers to the influence that they have over how drugs are prescribed, where drugs are prescribed, who fills the drugs that are prescribed, because they seem to have a lot of influence and a lot of control over how drugs are actually dispensed ultimately to the patient, where the physician dispenses the drugs. So this bill would require the Office of Insurance Regulation to examine pharmacy benefit managers for compliance with specific laws, require them to have standard contracts with pharmacies, and prohibit them from denying pharmacies and pharmacists the right to participate as contract providers. Because right now, pharmacy benefits managers are saying, we're not going to work with certain pharmacies, generally independent pharmacies, because they're kind of more of a pain for us to work with than the big pharmacies. So it's certainly something that you want to kind of keep an eye on. There is evidence that this bill and pharmacy PBMs just in general are going to be under attack from legislative bodies, whether they're national or state legislative bodies in the coming year and 2 years. It is certainly something where the legislatures and and the insurance companies honestly are focusing their energies and efforts right now because PBMs are making a lot of money that maybe should be passed on to the pharmacists or to the patients ultimately. So it's certainly something that you want to keep an eye on if you have a pharmacy in-house, or if you have, if you have a relationship with a pharmacy, if you're a 340B provider, if you're an infectious disease physician, anything like that. If if your practice interacts daily or a lot with pharmacy providers, that's certainly something you want to keep an eye on. So we're going to continue on with reproductive access. This is something that is obviously very controversial. At the as of the middle of last year, the Supreme Court came out and said that abortion is reserved as something a state should have control over rather than a national government. So in reply to that, the federal government came out and said that there was a federal executive order issued and another one right after it that we'll get into. But the first executive order directed the federal government to identify actions that it can take to protect access to reproductive health care services, including abortion and emergency medical care. We have obviously politics on one side of the aisle from the national side, and on the other side of the aisle in this state from the state side. So they're kind of bouncing off each other, as the federal government is doing in a lot of states right now that maybe are a little bit more conservative. So what they're saying, what this executive order says is basically from the federal side, staying within the bounds of the Supreme Court ruling, what can we do to preserve access to reproductive health care services, which would include abortion and emergency medical care. And it also directed the Attorney General to address potential heightened safety and security risks related to the provision of reproductive healthcare services, including the privacy of the patient. So that's certainly something that they came out with almost immediately after the ruling came down, and it's something that a lot of states have taken issue with. Within a week or so after the first executive order, the second one came out, which directs HHS to advance access to reproductive health care through Medicare patients traveling across state lines. So obviously Medicaid is administered by the states, but it includes federal healthcare dollars. So the federal government, or in this case, the president had said, look, we want Medicaid funds to be available to patients who are traveling across state lines from, say, a state that doesn't or from a state that prohibits abortion to a state that doesn't prohibit abortion. And so that's something that's still kind of, in the court system, and certainly is up for debate right now as to what happens next. It also directs HHS to consider all appropriate actions to advance the prompt understanding and compliance with federal non-discrimination laws by healthcare providers that receive federal financial assistance. So if a healthcare provider receives federal dollars for whatever reason, then it is certainly the federal government is, say, flexing its muscles at this point to say that we're trying to do everything we can to preserve reproductive access, and you will, if you want to continue receiving those dollars, you'll kind of be with us. So they're considering those actions. They're taking a look and kind of combing through the federal powers that be right now in order to assume a position to allow for reproductive healthcare services across state lines if need be for persons who need that. Okay. Florida House Bill 5 was passed last year. It is now law. It prohibits an abortion after the gestational age of 15 weeks. This is something that was prohibited into the third trimester of care. Prior to House Bill 5, abortion was prohibited in the third trimester, subject to certain exceptions. Now that age is reduced down to 15 weeks. This law provides an exception where a fetus has not achieved viability and two physicians certify in writing that the fetus has a fatal fetal abnormality, which is a defined term, based on reasonable medical judgment. So if two doctors determine that a fetus has not achieved viability, which again is a medical determination to make, and that the fetus has a fatal fetal abnormality, then the abortion can go forward as an exception. That was one of the only exceptions to the law at that point. So that is certainly something that hospitals and OBGYN practices, pediatricians' offices, primary care offices, they have to make aware their physicians and their healthcare providers, because this becomes a crime for the doctor if the doctor does something that he or she is not supposed to do. Now, yesterday, and this was what I was adding into my my presentation this morning, House Bill 300 was proposed. It is, again, a proposed law. It is brand new, and it is something that when I was watching the news this morning, kind of put my radar up and thought to myself, well, that's timely for my discussion today. This law prohibits physicians from knowingly performing or inducing a termination of pregnancy after a gestational age of 6 weeks rather than 15. There are exceptions, but again, that is a large adjustment downward. And it is certainly something that you'll want to keep your eye on as it kind of winds its way through the Florida legislature. There are exceptions that are in this proposed law. One is if two physicians certify that the mother's life is at risk. Another is if two physicians certify that there's a serious risk of imminent, substantial, and irreversible physical impairment of a major bodily function. And three is if the mother is a victim of rape or incest, which is a determination that it's kind of it's not well defined who gets to make that determination. So it's certainly something that warrants further inquiry. Again, this law was just introduced yesterday. It is not a law yet. It is proposed. There is likely to kind of see several iterations as it's wind its way through this legislative timeline. The legislature is in session until May 5th of this year. So there's a couple of months where it's going to wind through some committees, may or may not die in committee. We don't really know, but it is certainly something that you'll want to keep an eye on if your healthcare providers perform any sort of pregnancy services, and certainly keep your healthcare providers abreast of. So current takeaways for Florida physicians with regard to reproductive access is that they may perform positions after 15 weeks only in limited circumstances. However, patients may travel across state lines to obtain an abortion after 15 weeks. So, when they're advising their patients on what to do, that's kind of where we stand today. It might not be where we stand tomorrow, but that is where we stand today. Okay, moving on to telehealth. As of May 11th of this year, the public health emergency will end. What this means is that any sort of flexibility in the telehealth world that has been given during the COVID-19 public health emergency will be restricted or retracted. I think when it was put out that May 11th would be the end date, the federal government thought that that would be enough time for Medicare, insurance providers, anybody who has any sort of stake in the telehealth industry to make adjustments to their contracts or the laws or the rules that would allow them to either continue providing telehealth in limited circumstances or not. So the expansion of telehealth that occurred during COVID is going to contract. We don't really know how much, but we do know it's going to happen. And so that's a big deal for a lot of healthcare providers, my clients included, and we are waiting all with bated breath to try to figure out what comes next. There have been some permanent changes in Medicare while the public health emergency pended. First, and generally, these apply in the mental health space and in the rural health space. Generally, federally qualified healthcare centers and rural health clinics can serve as a distant site provider for behavioral or mental telehealth services. If you'll remember way back to 2019, for a Medicare beneficiary to avail themselves of a telehealth encounter, there needed to be an originating site and a distant site where the physician was in the originating site and the patient was in the distant site. And they were sites that were recognized by Medicare as such. And that would allow, and a lot of times this was an allowance for people who live out in rural America to, say, access their local hospital, and then their local hospital would remote to a, say, a hospital that had a specialist that maybe the rural hospital didn't have, and allow the patient to access care that way, specialty care, or care from, say, renowned physicians, things like that. So just kind of reverting back to that right now, which is what we've got to do once the public health emergency ends, pending any, if there are no other changes made, then these federally qualified health centers and rural health clinics can now serve as the distant site where a patient can go to receive the telehealth services from an originating site, which would be another hospital or an originating site that's been identified by Medicare as one of those. Medicare patients can receive telehealth services for behavioral and mental health care in their home. They do not need to go to a distant site. That's a big change from what it was before. There are no geographic restrictions for originating sites for behavioral or mental health telehealth services. So a physician in Pensacola can provide mental health services to a patient in Key West, no problem. There are no, behavioral and mental health telehealth services can be delivered using audio-only communication platforms, which is big because it used to have to be contemporaneous audio-visual. So now it can be done via the telephone only. And rural emergency hospital departments are accepted as originating sites. So, a physician there can provide services to, say, a rural health clinic without needing additional certifications from the federal government. There are some Medicare exceptions that have been put in place through 12/31/24, so through the end of next year. Again, this would allow for certain services, or this would allow for government agencies to have a little bit more time to enact rules, and I think that's why they decided to do this. Federally qualified healthcare clinic or centers and rural health clinics can serve as distant site providers for non-behavioral mental and behavioral health services. So for, say, physician services that aren't behavioral or mental telehealth services, the patient can still travel to the rural health clinic and receive distant site services there. Medicare patients can receive telehealth services authorized in 2023 in the Medicare physician fee schedule in their home through 12/31/2024. There are no geographic restrictions for originating site for non-behavioral or mental health services. So again, a physician in Pensacola can advise somebody sitting in Key Largo. There are some non-behavioral or mental telehealth services that can be delivered using audio-only communication platforms. Generally, if your practice is providing telehealth services, I would advise that you have a contemporaneous audio-visual platform to provide those services, just to kind of stay in the know. What you don't want is your physician providing telephone services to somebody when he needs to be able, or she needs to be able to see the patient face to face. So certainly something that you want to keep an eye on there. An in-person visit within 6 months of, generally an in-person visit for a telehealth, behavioral or mental telehealth service is provided, and annually thereafter. This is not required at this point through the end of 2024. And then telehealth services can be provided by a physical therapist, an occupational therapist, speech language therapist, speech language pathologist, or an audiologist through 12/31/2024. Florida has been also updating its telehealth laws both during the pandemic and before the pandemic. Generally, controlled substances are allowed to be prescribed if they are Schedule 3, Schedule 4, or Schedule 5 via telehealth without limitation. Last year, the Florida telehealth laws were updated to allow the prescription of Schedule 2 controlled substances when treating a psychiatric disorder or providing inpatient care at a hospital. So the physician can be at home providing, and call in prescription, or a patient receiving hospice services or a resident of a nursing home facility. Schedule 2 controlled substances are appropriate at that point. There are some telehealth laws proposed in this legislative session in Florida. One is to revise the definition of telehealth to include audio-only telephone calls. So the Florida proposed laws are a little bit different than the federally proposed laws because they would include all insurers and self-insured patients. So we're not just talking Medicare here, we're talking all insurers. Of course, if you've got a contract or your practice has a contract with a insurer, it will likely govern how you're providing telehealth. So you want to look at that first. But generally, this one proposes that the definition of telehealth is revised to include audio-only telephone calls. So again, without the need for audio-visual. I don't think that one will go through. I think that audio-visual is important. And I think that it's something that will stick around. House Bill 117 proposes to add genetic counseling to the list of licensees that are authorized to provide telehealth. There has been an absolute explosion in genetic lab services and genetic counseling during the pandemic. I think it probably doesn't have a whole lot to do with the pandemic. It probably has a lot to do with the fact that telehealth has exploded during the pandemic as well. And so genetic counseling is something that has also grown with the expansion of telehealth. So if you say get a lab test back or a genetic lab test back that says you've got a predisposition for something genetically, it would be wise to have a genetic counselor on staff to follow up with your patients, and this would allow them to do that via telehealth. I think this one probably will be added, if I was guessing, but the legislature has surprised me in the past. And then you have House Bills 387 and accompanying bill, Senate Bill 344, which would allow physicians to recertify a patient for medical marijuana using telehealth. Currently, patients are required to recertify in person every 30 weeks. Now this would say you could do it without having to have that biennial encounter. I don't know if this one's going to pass or not, but it is certainly out there and something that you want to take a look at. Well, that's my kind of top-down screaming locomotive of the legislative update, and I hope that it's helpful to you. If I've said anything here that you need, clarification on, I'm happy to do that. My contact information is here. I think it's important that as healthcare providers and as administrators from healthcare providers, you stay on top of what's known to you. The Palm Beach County Medical Society does lobby, and if you see something in the Florida statutes that kind of gives you pause or cause for concern, you certainly can contact them to get a little bit more insight. Any laws that have passed, including the No Surprises Act, which unsurprisingly is very hard to understand in a lot of cases, I think it's important that that you educate yourself on that. If you're an out-of-network provider or your practice is an out-of-network provider, that services in-network facilities, because again, it is on the physician to ensure that certain notices and consents are required prior to services being rendered. That's my big takeaway here is if you are part of the part of that group, then you certainly want to make sure that you are on top of what's happening there. I could do a whole hour or more on the No Surprises Act, and it's certainly something that you want to kind of keep abreast of. I hope that this has been beneficial to you, and I'm going to turn it back over to Mindy at this point.
Anybody have any questions? I think you were so thorough that nobody has any questions.
It's a lot, and it's hard to keep organized because there's just so many moving parts. So if it seemed a little disjointed or a little more disjointed than past presentations, I apologize for it, but it is a lot to kind of keep on top of.
And of course, if anybody's like me, and I'm always like thinking about something the next day, and then I have a question. So you can always email Jacqueline, or you can always email myself, and I'll reach out. And this, like I said, this will be on YouTube. So if you have anybody that you think is, this might. Somebody's got a question.
Here's a question. So the question is there still a ton of sensitivity around opioid and Suboxone prescribing via telehealth? And the answer is yes. Right now, there is a proposed law about how, the Ryan-Hyde Act, which is a federal law, required an in-person visit prior to prescribing those kinds of drugs to a patient, and it still does that. There is a proposal right now that would allow for a 30-day supply to go to be had by a patient prior to the inpatient, or the patient encounter with the physician, but that hasn't been passed yet. So as of May 11th, at least as of this point, you'll want to have in place a mechanism to see patients in person before you prescribe those kinds of drugs. The second question that just came in, can I do telemedicine on my patients when they're in another state, on vacation, or seasonal? And the answer is, it depends on the state. Most of the time, if you are in another state from your patient, you're required to have some sort of license in that state to provide those services, telemedicine services. Generally, you could call in a prescription for them in another state or something like that. But in terms of encountering them while they're in that other state, then the state will likely require you to have some kind of license or registration. Florida, in particular, has a registration here, so that, say, physicians in New York can register as a telemedicine physician here without having to go through full licensure. So my advice to my clients when that comes up is take a look at where your patient population is when they're not in state generally. If they're from the Northeast or Ohio or a lot of places that they might come here as snowbirds, you might consider obtaining licensure in those states to allow you to provide those services.
Any other questions? Well, thank you, Jackie. You're amazing. You were super informative. So you were so good. And I thank everyone for coming today.
Thanks, guys.
Thank you. Everybody have a great day.